There's no way to oppose the Constitutional Court's interpretation of the law, for better or worse. In this case, for better, because the Constitutional Court's argument is perfectly correct.
Last week, the Constitutional Court ordered the Electoral Commission to proceed with the local government elections before the 1st of November. But question marks are now being raised around the IEC's decision to reopen the candidate nomination process. Joining me to discuss is Gabriel Crouse. He's with the Institute of Race Relations. Gabriel, welcome back to the CRA channel. We're recording on Monday. What did the IEC announce today, and what are the implications of that announcement?
So the good news is the IEC said that it'll be able to reopen voter registration on the weekend of September the 18th, 19th. And that means that all the people who were effectively disenfranchised by Kota Minister Nkosazana Dlamini-Zuma's premature proclamation on August 3rd are going to get the chance to have a promised in-person registration weekend. That's good. The bad news is the IEC said it's going to reopen the candidate nomination process. All the major opposition parties, DA, the EFF, have been against this. The ANC has very much wanted it. So it suits the ANC. I don't believe that it's consistent with the Constitutional Court order, and therefore it's illegal.
So why do you believe it's not consistent with the court order, Gabriel?
So the Constitutional Court was confronted by a variety of arguments and a variety of remedies that parties were seeking out. These arguments drew attention to exactly the facts that the IEC is going to has mentioned. The two remedies sought by the EFF were denied by the court. The one was lifting a political ban, a ban on political gatherings. Another was exactly this, reopening or extending the deadline for candidate nominations. The court said we're not going to do either of those things. And so effectively what the court said is, although usually you have voter registration closing and only after that candidate nomination closing, this time we're going to do it the other way around. The candidate nomination has already closed. We're not going to extend the deadline, but the voter registration will be reopened and then close. So that's what the court said. The IEC is saying, no. We need to have things the way they usually are. And usually it's voter registration closes, then candidate nomination closes. So that means if voter registration reopens, candidate nomination needs to reopen. They're giving a legal argument that the court did consider and ruled against. It would have been a completely different matter if the IEC brought a factual argument. They said something happened after the court had finished deliberating that the court didn't think about, and that's why we need to reopen the candidate list. That would have been fine, but they didn't do that. They gave a legal argument that the court did consider, and therefore it has no standing. There's no way to oppose the Constitutional Court's interpretation of the law, for better or worse. In this case, for better, because the Constitutional Court's argument is perfectly correct. To give you a sense of why, it's because the people that want to be on the party list that haven't registered to vote could easily have done so using the extraordinary measures that the IEC did allow before that process was closed.
Enjoying this analysis? Click here to sign up for our 30-day free trial for more content from the CIA.
Gabriel, do you think that the IEC is giving special treatment to the ANC?
It clearly is. This argument that they've given is fake legal nonsense. And it's not the first time that we've seen fake legal nonsense come out of a major elections announcement. I think the biggest one, but not the only one, is August 3rd, when Nkosazana Dlamini-Zuma proclaimed the election. She said that she was had to do so on that day, because only then could the IEC go to the Constitutional Court the next day. That wasn't true. The IEC knew it wasn't true. Its lawyers had already told Dlamini-Zuma that it wasn't true. And her letters showed that she believed it wasn't true. So Dlamini-Zuma lied, and the IEC knew she was lying about an elections matter during a proclamation. Did it correct her? No. It acted as a servant rather than as a guardian, a Chapter 9 institution of South Africa's public interest. It's doing so again now. The reasons that it's giving are the same kind of legal nonsense that Lamini Zuma gave a month ago. If tested in court, we're as confident this time as last time that it will be rescinded, and we were vindicated in our earlier judgment. However, there is a major risk this time. And that risk is the following, that the IEC buys itself time by opening up the process, opening up a new route for legal challenge, and that in that time, the deadline and the necessities to meet that deadline are obscured, distracted, and obstructed, such that we miss the constitutional deadline or only achieve it by completely abrogating the process. In either event, creating the preconditions for saying this election is illegitimate, which is what the IEC has always been doing, and therefore to say we need to try again in 2022, or maybe even better, try again in 2024, as the ANC has been calling for over a decade.
Gabriel, earlier today, Monday, as we were recording, Helen Zille put out a series of tweets asserting that the IEC has basically succumbed to institutional capture on behalf of the ANC. Do you think that this is an overstatement, or do you think that her criticism here is valid?
I went on record shortly after those tweets to say that I thought Helen was wrong. She put the tweets out at noon. At 1 o'clock, I was saying, no, she can't possibly be right. This is too extreme. The IEC could not be that brazenly corrupt. And then at 3 o'clock, she was proved right and I was proved wrong. To get a sense of how bad this is, you have to go back to when Becky Cele was in the position of facing a constitutional court order to arrest Jacob Zuma. And legal arguments were being put out that the order was actually confusing and we weren't sure what the court really meant. And South Africans were worried that Zuma might therefore not be arrested. But it went ahead. He was arrested because the court was clear. And to do otherwise would have been to demonstrate that the entire police service has been captured by the ANC. That was too crazy to happen. We thought it was too crazy for the IEC to do the same thing, but we were wrong. The IEC has gone against the Constitutional Court and for the ANC, and it's a gloomy day.
Gabriel Crouse, thank you very much for joining us on the CRA channel. A message to you, our viewers, is that we at the CRA will be hosting an exclusive client webinar this Thursday, the 9th of September at 1 o'clock. There are details in the description below where you can register for this event. If you're not yet a client of the CRA, you can also join us on our 30-day free trial, and you can gain access to this event through that route. My name is David Ansara. This is the CRA. Until next time, take care.